outside your comfort zone, because we're going to talk about civil litigation. Now, it may not be a regular venue to be in a civil court, but who knows, you might end up in one. And if so, it's very different than being in a criminal court, as I'm sure you know. The complexity of the terminology is vastly greater in civil. If you were to take the complete annotated codes of the state of California and to line them up, it would take, from about that white bracket there to here, it would be 3 shelves up to here. 4 of those volumes would be criminal law. The rest would be civil law. So when you consider that for a moment, in a criminal courtroom, you're presented largely with the same issues and the same terminology over and over and over again. In a civil courtroom, you will be shifting back and forth. In a criminal courtroom, all of the law is modern. In a civil courtroom, we have vestiges going back to ancient times, as we'll see today as we discuss some of the terminology. Civil law is an accretion of principles. Criminal law was very simple in ancient times. Civil law, which is absolutely requisite for any government if they wish to have a stable economic system. So contracts, the relations between a family, taxation, maritime law, trade law, all of these must change, keeping the principles that were useful, discarding them, and amending them when policy so demands. For instance, if you're a criminal lawyer, you don't have to go back very far because criminal law continually modernizes. Whereas if you were a law student and you enter your real property class, they will torture you with the Duke of Norfolk's case, also known as the rule against perpetuity. Excuse me, this was supposed to be turned off. I'm just going to let it ring. It has the little moon up there, but for some reason it's still ringing. At any rate, the rule of perpetuities. Any contingent remainder must vest within 21 years and 9 months of life and being. What does that mean? I'm not going to bother you with that. But that's the sort of rule that they're going to give you if you're a civil law student in real property. You go back to sub-imputation, to feudal times. So interpreting in civil litigation can be tremendously complicated, and you can suddenly come up with a term that even the lawyers can't pronounce correctly. Common terms have assumed meanings. Okay, many of the words that we use have ordinary legal meanings, but in law we call them terms of art. And the ordinary meaning of the word is at variance with the legal meaning of the word. Now I know it's not your job to do anything more than interpret the word for your clients, that you cannot explain to them what it means or what the legal impact is. That's not part of it. But I felt that perhaps you might be interested for your own purposes in knowing the context of many of these procedures and many of these words that have particularized meanings. If at any time, by the way, I've handed out from the state of Connecticut a glossary. I know interpreters like glossaries. Anyone here doesn't like glossaries? That's unanimous. We all like glossaries. I'm not going to go word by word in that glossary. There are many criminal law terms in there, but I wanted you to provide you with one. Many of the words on there you can follow me along with. I'm not going to dwell on Spanish meanings, except if there's a point of particular interest. What fascinates me is we don't have such a glossary on LA Superior Court's website, at least not to my knowledge. And as far as I know, we're the most polyglot court system in the world. So why that is, I don't know. And why they don't get permission of you to do it, I don't know either. But let's start right in. Let's talk some very simple examples. But people assume that they know what words mean. What is a contract? Everybody would say they know what a contract is.
An agreement between two people.
An agreement, right? Well, you can have an agreement that's not a contract.
Legal.
A written agreement.
Written legal agreement.
It doesn't have to be written. It can be oral.
Offer, acceptance, consideration.
Those are the elements. But if you wanted to define a contract, most lay people would go along the lines you do. Well, it's an agreement. Well, we can agree that Dmitri Shostakovich was one of the greatest of the modern Russian composers, but that's not a contract. Okay. We can agree on a great many things that's not a contract. You can also have offer, acceptance, and consideration, and you still would not be able to win in court. Why? Because what a contract really is a set of mutually enforceable promises. They are promises that our government will enforce, down to the point of having enforcement procedures that you can reach into the person's bank account. Yes?
Can you repeat the definition you just said?
A set of mutually enforceable promises. However, a caveat, the promises can be implied. They do not need to be expressed. And so when we use the term contract, it actually is an entire universe. There are written contracts, there are oral contracts, there are contracts implied by law, there are contracts implied by conduct. There are many different types of contract. And civil law has a great deal of specificity about it. When we just use the word contract, though, everybody thinks they know that they think they're on the same page, but they're not. The promises have to be mutually enforceable. For instance, in California, generally speaking, a gambling contract is not enforceable unless you make that contract with one of the state licensed pari-mutuel agencies or an Indian casino. It's a contract which is not enforceable. You could make an agreement with offer, acceptance, and consideration with a 17-year-old, but it wouldn't be enforceable. So when we say contract in law, we're normally talking about something that is enforceable in law. This is the backbone of any national economic system. People will not invest in a country's enterprises unless they have some confidence that they have a remedy should the other side not perform. Now that's just a simple example of how an ordinary English word, once turned into a legal term of art, becomes tremendously complicated. Let's look at an overview of the civil litigation system. I'm going to go through this very quickly. I'm a research attorney, which means I've spent decades now analyzing briefs that lawyers file at the court. And I might as well be an interpreter because sometimes they're absolutely unintelligible. And I have to turn them back into ordinary and comprehensible English. I know often what they're trying to say, at least, but not always effectively so. Most civil attorneys are not the articulate individuals you might expect them to be from watching Atticus Finch. The civil litigation system is mostly about money. Mostly. But there is about other things. It's also about vindications of rights. You can get injunctions against people, stopping them from doing something they shouldn't do, forcing them to do something they should do. We'll cover a little bit later on procedures such as writ of mandate, where you can force the government to do what it should do. Where if the government won't give you a permit to build on your vacant lot, you can force them to give you a permit to build on your vacant lot if they have abused their discretion in the administrative process. So civil law is about not just money, but about all economic relationships and about the relationship of citizens to the government. In civil litigation, actions are normally commenced by sending a series of nasty letters. I'm going to gloss over that portion and go to the formal commencement of the civil litigation process, which is the filing of a complaint or the pleadings. We go into the pleading stage. Now, although most attorneys aren't aware of this, the Code of Civil Procedure tells us that all you need to do to make a complaint, a viable complaint, is to state the facts, and this is a quote, in ordinary and concise language, and a prayer for a remedy. That's all it requires. It does not require any heretofores, here and afters, now comes plaintiff. Those are all relics. Those are all relics from the common law, when if you did not plead your writ precisely, you were out of court. We're no longer in those days. We believe in liberal pleadings. CCP 452 says a complaint shall be liberally construed by the court with an eye to substantial justice between the parties. That's a lot of wiggle room in deciding whether a complaint is sufficient. After a complaint is filed and served, we'll get into those terms later on, then the defendant or defendants file a number of pleadings. They can either accept the pleading and file an answer. An answer is a response to that complaint. Modernly, you can file what is called a general denial, which says, I deny everything. That's it. However, you can also interpose affirmative defenses. What is an affirmative defense? It is new matter not embraced by the complaint, which would constitute a defense to the allegations that have been made. An affirmative defense is one on which the defendant has the burden of proof. It's new matter. It's completely different. The defendant can also file a cross-complaint, either against the plaintiff or against anyone else involved anywhere. Often this is done by way of a cross-complaint for indemnity. People, instead of filing an answer, can file what's called a demur, which we'll talk about. It's a challenge to the pleading. I'll go on to that. Or you can move to strike portions of the pleading. Eventually, we settle which part of the complaint is going forward, which part is not. We have an answer. The pleadings are joined, and the issues to be litigated are defined by those pleadings. If they're not there, you can't litigate them. You can't raise an affirmative defense by surprise. All modern developments in law have been meant to prevent surprise or litigation by ambush, that everybody should have a level playing field and be able to fully anticipate what the issues at trial are going to be. Once we've settled the pleadings, we enter what's called the discovery phase, where language is butchered wholesale, because people can ask whatever questions they wish of the other side in a myriad number of forms, which we'll go into in just a few minutes. However, the attorneys draft these, and in an attempt to be lawyerly, they use language which becomes so overbroad that the other side simply objects, I don't know what you're talking about. Or they will level a bunch of evidentiary objections, which are equally thoughtless. But nevertheless, this is perhaps the most expensive and prolonged portion of civil litigation, which is trying to discover what the other side's contentions are, what facts they have, what documents they have, what position they're going to take at trial. After we've done our discovery, we move into what's called the dispositive motion phase, where one party can seek to obtain judgment short of trial.
Can you repeat that, this one?
I'm sorry?
Can you repeat that one?
Dispositive motion. The dispositive motion. We call it a motion for summary judgment or summary adjudication. What is the purpose of having a trial?
We can have the judge make a ruling.
No, because most of our trials are jury trials.
Never mind.
Okay. And that's the whole point. Why do we have a jury? We have a jury because the facts are in dispute.
Right.
And the province of the jury is to determine what the true facts are. If someone says that it happened, the accident on November 10th, and the other side says, no, it happened on November 9th, it's up to the jury to decide which of them is accurate and which of them is not. If someone says they ran the red light and someone says, no, it's the other party who ran the red light, it's the jury. Their job is to assess credibility and to make a determination of facts. If there was no dispute about the facts, you don't need a jury. And the judge can then rule as a matter of law. In other words, it becomes a pure question of law. So in the dispositive motion phase, one of the sides comes forward and says, here's a set of facts which are undisputed by the party that we've learned during discovery. Based on these facts which are not disputed, we are entitled to judgment. Doesn't work as often as they'd like. But they try, because it's a very expensive procedure and they get billed for it. Oh, sorry, I'm destroying the rules of the guild here. But a great deal of litigation is protracted precisely for tactical rather than efficient reasons. After we get past that phase, then we get into the pre-trial phase, which are called motions in limine, where people move to exclude certain types of evidence from trial as being more prejudicial than probative, as being irrelevant. They can challenge an expert as not having sufficient foundation to express their opinion to the jury. All of these are complicated issues. And then, of course, there's trial. Then there's post-trial motions, where we talk about attorney's fees, where we talk about whether or not we should vacate the jury's decision because there were errors in instructing them, or the jurors themselves committed some sort of misconduct. And finally, it goes out of our hands into the Court of Appeal. In brief, that's the civil litigation. It sounds short, but it's very long. Currently, it takes, well, we try and get every civil action to trial within 2 years. Most judges will put attorneys' feet to the fire if they want to go past 2 years from filing. But there are certain types of cases, complex litigation, and other types, which are not bound by that rule and can go on for years, many years. Yes?
So what is a brief?
What is a brief? It's not very brief. A brief is a written statement of a party's position. First, let's come up with a more fundamental question. What is a motion? Does anybody know what a motion is? It's quite simply defined as an application for an order. You want a particular kind of order? You bring a motion. You move to have the court grant some sort of relief. To do so, due process requires that you give notice in writing of what it is you're seeking, the legal basis for your request, the time and place at which the motion will be heard. The other side has an opportunity to file an opposing brief. In California, a brief is not supposed to be more than 15 pages unless you get specific leave from the court to file an oversized brief. The exception is the summary judgment, which can be 20 pages long. In law school, the joke is, when they criticize law students, is we call it a brief because it's shorter than the case that you read, or at least it's supposed to be. Briefing, there are lots of theories about it. It's the person who actually reads them. As always, I think being concise is the most important part, but most people don't follow that philosophy and do not organize well and do not reach their point with.
So in this whole set of procedures, filing, complaint, where does the brief come in?
Where does the brief come in?
Yeah.
There are several places where briefs come in. As I say, if you want the court to do something for you, you file a motion which includes a brief. We call it a memorandum of points and authorities. Legal points and the authorities which support that point. But brief is also used in connection with trial briefs, where each side gives a summary of what they believe the facts of the case are and what the issues of the case are. So when you hear, this is once again our problem with civil, you will hear the term brief, but it will be used in several and various contexts. Most of the time when we use the term brief, we're actually referring to the memorandum of points and authorities. The page limit does not apply to the evidence which you wish to attach to your motion. I've given you an overview. Let's start talking about some specific terms, and I'm going to start with the big five-star one. A word that everybody knows, jurisdiction. Pretty easy to translate that word. I think I can probably do it. But what does it mean? Unfortunately, yes.
It means that the court that you're before has the authority to rule on that matter?
It does mean that sometimes.
Sometimes.
This is our problem. There are several different types of jurisdiction that we talk about. And normally people don't, well, lawyers, when they're talking fast, they don't distinguish between them. So if you were interpreting a motion hearing for somebody and somebody is using the word jurisdiction, they could be referring to subject matter jurisdiction. They could be referring to personal jurisdiction. They could be referring to court's jurisdiction to act. They can refer, well, let's go over what those are. Subject matter jurisdiction. Not every court can decide every type of case, as we know. For instance, patent law. You have to go to federal court. If you file a patent lawsuit in state court, we have to throw it out. We have no power to rule on it. But sometimes the federal court sees fit to give the state court concurrent jurisdiction over federal law. And that's normally a big headache. Maritime law is a court of federal jurisdiction, but we are given concurrent jurisdiction over the Jones Act, which is the Compensation Act for injured seamen. And we have jurisdiction, concurrent jurisdiction over common law claims for unseaworthiness of a vessel. Now there's another great word, unseaworthy. Even when I say it in English, I'm not conveying what the essence of that action is. When we say unseaworthy, what image pops into people's mind? A leaky boat, a dilapidated hulk that's taking on water, that the rats have put on parachutes and are jumping off the ship to get into the water. That's not what unseaworthiness means. At law, a ship is unseaworthy if it is not fit for its intended voyage. So a ship could be unseaworthy if it did not have enough lifeboats on it to count for the crew and for passengers. That vessel is unseaworthy even though the hull is watertight and the ship is brand new. See the Titanic for that particular problem. Okay. Interesting case I had once dealing with unseaworthiness is this. Believe it or not, there's a company down in the harbor, LA Harbor. They're a contractor for the Navy, and their employees get little boats and they tow targets for target practice for people who are learning to shoot guns off of a destroyer. Sounds like an interesting job. Having people new at the guns shooting at you. They also help in training people to respond to terrorist attacks. Some years ago, the Navy was stepping up that type of training because there were so many I won't say terrorist attacks, but pirate attacks off the Horn of Africa. And so they were training people how to respond to that, in case you're interested in knowing, if you have a destroyer. And these little guys come out in these very fast cigarette boats or whatnot. You're supposed to take your larger boat and go zigzag, like this, because that creates these conflicting wakes that will often disrupt these smaller boats. So that's the type of training that was going on the day of the case. And what happened? These fellows are out there in little boats and they have lights that you can shutter on and off that simulate gunfire. You know, in other words, if you're hit by the light, you've been hit by gunfire. You learn something new every day in school. Okay, and here's something, they're circling around the boat like this, pretending that they're in an attack. The rules say that every time you come around the ship, you must radio to the other ships so they know you're coming around, so there are no collisions, no surprise collisions. In this case, one of the fellow came around, and it was a handheld mic, not like these I have here, and he had to look down to grab it and pick it up to say, I'm coming about, and as he looked up, he saw a huge wake of the ship coming right at him, and it flipped him over like this. He wasn't killed, but he was injured. And he sues for a theory on seaworthiness, saying that for the type of voyage you intended the ship for, you should have had wireless voice technology, so I wouldn't have had to have taken my eyes off of the horizon. And he won. The ship was unseaworthy. So there you have it. The common English word doesn't even begin to describe the nature of the cause of action. So, but we were talking about jurisdiction. Subject matter jurisdiction is the power of the court to hear a particular case. Personal jurisdiction is jurisdiction to render a judgment against an individual, a corporation, or some other sort of entity. This is the fundamental due process guaranteed by both the federal and the state constitutions. So, in order to do that, you must strictly comply with the rules governing service of process. You must serve them with a summons, telling them that they must appear in court within 30 days and file some sort of response. Even if a person knows that there's litigation against them, they don't have to do anything until they're served. And if you're not properly served, you can contest the court's jurisdiction. We'll talk about that a little bit later on. Personal jurisdiction has many facets to it. For instance, what if the person who you wish to sue is out of state? Does the state of California have the ability to render a judgment against them? Sometimes yes, sometimes no. That's an entire law school class in itself, the acquisition of jurisdiction of out-of-state defendants. And then there is jurisdiction with a small j, which is what this table was coming at, which is the legislature is the one who passes in our trilateral form of government. It's the legislature which makes the laws, and they can put limit on those laws that limits the court's power to act. For instance, somebody who doesn't respond to a complaint within 30 days can have their default entered. Once a default is entered, they can no longer answer, they can no longer respond, they can no longer defend. All the plaintiff has to do is submit proof of their case, and they get a judgment. There's nobody to defend the case. However, there is a procedure, Code of Civil Procedure 473, that allows you to vacate a default based on mistake, surprise, inadvertence, or excusable neglect. Once again, some very, very broad terminology there.
I'm sorry, for what reasons?
Mistake, surprise, inadvertence, excusable neglect. But the statute says that the motion must be brought within 6 months. After 6 months and 1 day, the court loses power to vacate that, no matter how good a reason it might have been. After 6 months, the legislature has said the court has no power to grant relief under CCP 473. Does that mean you're out of luck? No, there are other procedures that can be used. But that is an example of jurisdiction with a small j. For instance, in most motions, like I said, you have to serve a notice of motion on the other side. If you do not do so, then the court cannot act. Okay? It does not have the small j jurisdiction because the other side has not had notice and an opportunity to respond. So that's the small j jurisdiction. Which one are people using at any one time? It's all contextual. It's all contextual, and there is the challenge for the interpreter. If it's a motion to quash the service of summons, you know by implication that it concerns personal jurisdiction. If it's a motion to strike the complaint, you may infer that it deals with subject matter jurisdiction. Motion to strike lies where a complaint is not filed in conformity with law. Now, jurisdiction is not to be confused with venue. Venue is where do we bring the lawsuit. Venue is very different, and venue can be waived, even if it's every court in California, which is a court of general jurisdiction. If nobody objects to the venue, that court has jurisdiction. But you can object to venue as being improper, and then we have to decide when and where, or rather where, this case should properly be heard. Generally speaking, in a civil action, venue is proper in a number of places. It is proper where any defendant, in the county where any defendant resides. It is proper if you're dealing with an accident for personal injury, the county where the accident occurred. That's proper too. And if it's an action on contract, it's proper where the contract was to be performed. And that is a very complicated issue indeed. As you may know from your own personal contracts, where is an insurance contract to be performed? Where you are, where the insurance company is, where the covered event took place. Where the contract is to be performed can be a knotty legal question. Knotty with a K, not A-G-H-T. It's different word altogether. So, let me go back into terminology. Pleadings and attacks on pleadings. When you are served with a complaint, you have a number of options. And one of the most popular is the filing of a demurrer. That's D-E-M-U-R-R-E-R. Anyone know the derivation of that word? It comes to us through Norman French by way of the Romans, who most of European law is based on Justinian's Codex of Roman Law, as opposed to the United States law. We've adopted the term demurrer. The federal system uses the term motion to dismiss. But what is a demurrer? A demurrer is a procedure where the defendant says, let's assume every fact in the complaint is true. Every properly pled fact is true. Even if you could prove every single one of these facts, and we're assuming you can, it does not state a claim on which relief can be granted. Let's give an example. You're in a car accident and you plead that the other person rear-ended you and that they were drunk and that you were lawfully stopped when they rear-ended you. It all sounds like a good case, but it's missing an essential element: damages. Unless you plead that your car was injured or that you were injured, you have failed to state sufficient facts to constitute a cause of action. Almost every cause of action requires that you have suffered some sort of damages to be compensated. Negligence, the most common tort there is basically want of ordinary care, want of due care. And you can be negligent in any number of ways. While having coffee and tea or a cocktail party, you could back up and bump somebody who spills their drink. That's negligent. Is it legally actionable? Not unless somebody was injured. If the drink was red wine and it fell on somebody's designer gown, they could sue you in small claims court for damage to their gown, or the host could sue you for the cost of cleaning the carpet, but the cost of litigation is prohibited, and so no one sues over those sorts of things. You have to have a fully ripened cause of action. Every legal theory of recovery has elements. Just like the gentleman back there in contracts said you have to have offer, acceptance, and consideration, so every theory of recovery has certain elements which must be pled. For negligence, yes?
No, I was going to say duty, breach, causation, damages.
It is. And now let's talk about causation, which I'll get into. What is causation?
When you actually can prove that the action of the party caused the damage.
That's only one part of causation. That is, cause in fact In civil law, you also have to have proximate causation. I'm jumping ahead now. Has everybody heard the term proximate causation? No, most people haven't. And it's another term that drives law school students crazy because the professors try and hide its meaning from them. It's rather obscure. From use of the word proximate, you would think it means close or nearby you. And it does, but only in the remote sense of proximate. I will tell you the short answer of what proximate cause is. It means that the result of your negligence was foreseeable. If the result of your negligent act was not foreseeable, the court, in fairness, in justice, can cut off liability. I will give you my favorite example of proximate cause. It comes from the early part of the century, I think it's 1907, a Baltimore case called the Wagon Mound case. Wagon Mound was a ship that was docked at the harbor, and a deckhand was working on the docked ship. There's an open hatch. He's working with a hammer, and he accidentally drops the hammer into the hatch. Now, had there been someone down there who'd been hit with the hammer, there'd be no doubt that there would be cause in fact and proximate cause. It's quite foreseeable that if you drop a hammer, you might hit someone beneath you. But that's not what happened in the Wagon Mound case. What happened was there were some flammable fumes down in the hold. The hammer struck a spark. The ship blew up. It started a fire on the dock. The fire spread and burned down almost the entire waterfront and several warehouses. There was no proximate causation. It is not foreseeable that in dropping a hammer, you would destroy the entire Baltimore waterfront. Okay? This is the beauty of this civil term. So when we say proximate, it does not mean physically close. It means that it's close to being able to foresee that if you make this omission or this negligent act, that damaging results will occur. And there are many instances where a simple negligent act results in far-ranging consequences that no reasonable person could have foreseen. There is a case pending in Long Beach right now, I recently had it, where you have a collision in the middle of an intersection. And the collision happened in just such a way that one of the cars ran into the corner where there's a disabled ramp. It happened to go right up the disabled ramp, and that building had a corner door, which is to say instead of a perpendicular joining, it had a truncated corner with a door in it. The car goes right through that door, across the restaurant, and it pins the person, a couple of diners, just in the middle of eating their guacamole. Fortunately, they weren't killed. They weren't killed. But the question is, and they sued, among other things. Here's the heart of civil litigation. Each of those people who caused the accident, whoever they were, had minimal insurance policies. $15,000 per individual, $30,000 aggregate. That's all there was. So the plaintiff settled with them for $60,000 total. That doesn't even begin to cover their medical bills, much less the cost of litigation. So who else are they going after? Why, the person who owns the building, of course, and the tenant who runs the restaurant that was inside of it. And they both said, sorry, no proximate cause. We could not foresee that a car would come into our restaurant. Sounds like a great defense, huh? It turns out that 7 years earlier there had been an identical accident. So the question in this case was, did they have a duty to prevent this same type of accident from happening again?
Yes.
Well, maybe they couldn't because they don't have the ability to put up barriers on a public sidewalk. And they can't put bollards in front of the door without violating the ADA. And they can't block the ADA compliant ramp that the city put in. So it's quite possible that even if the accident is foreseeable, they may have had no way to guard against it. These are the complexities of civil litigation. Everyday events have strange twists to them that you may never have contemplated in your life. bizarre situations, bizarre misuse of products. At any rate, we're back with the demurrer. And the demurrer says, a demurrer can say anything like that I didn't owe you a duty. Okay? I did not owe you a duty. For instance, somebody is walking down the street in front of your house and they trip over a broken sidewalk piece and they sue you along with the city. You can say, I don't owe you any duty. I don't own the sidewalk. I didn't have any duty to repair that. Aha, says the plaintiff, but you own the tree whose root system caused that sidewalk to go up. So you had a duty to use due care with respect to the tree in your front yard. Is there a duty? Possibly. Possibly not. That's a legal decision, whether or not there's a duty. The province of demurrer assumes every properly pled fact is true, but not contentions, deductions, or conclusions of law. I won't go into that. It's hard enough to describe that to attorneys. There are other types of attacks on the pleading. A demurrer goes to a cause of action. You can also move to strike, a motion to strike portions of a complaint. That means that the complaint might be legally sufficient, but they're asking for things that they can't recover. For instance, you have an ordinary fender-bender accident, and somebody asks for punitive damages. Punitive damages, as you know from the word, are punishing. When people have acted with fraud, malice, or oppression, in addition to your actual damages, you can get exemplary damages to deter people from this sort of conduct. But it's only available where the facts show there was fraud, malice, or oppression. In an automobile accident, it's hard to show that, unless you can show that the person had to have glasses and they weren't wearing their glasses, and they had a fifth of whiskey before getting behind the wheel. Then the facts change. In civil law, changing the facts a little bit changes everything. Motions to strike can also strike irrelevant portions. Because of our economic times, we've seen a great upsurge in people without lawyers filing litigation. They like to do character attacks on the defendants and talk about what horrible people they are. You can move to strike those allegations because they're not relevant to the cause of action. That you don't like them, that they're bad neighbors, that they're mean people, that they kick their dog, that they let their children stay up late and they have lousy taste in music. All of those things are irrelevant. Now you laugh, we get these cases. Neighbor cases are among the worst. They're like divorce cases. So that's a motion to strike. And now, the big and most popular in modern times, the special motion to strike, also known as anti-SLAPP, S-L-A-P-P, all in capital letters. Anybody here ever heard of that? Yes, we have one person in the back. SLAPP stands for Strategic Litigation Against Public Participation. The legislature, in its wisdom, came up with a procedure saying that many people were filing harassing lawsuits, and they passed a new law that says if the defendant can show that the complaint, the cause of action of the complaint, arose from their exercise of their First Amendment rights or their participation in government, then the other side has to show, even before any discovery, that they can make out a prima facie case, that they have a case with minimal merit. Otherwise, we dismiss it right at the outset, and the defendant gets their attorney's fees as well. That's what's made this very popular, is you can get your attorney's fees. And there's scads of law on it. People try and use it to get these attorney's fees. Not that that's bad. In the proper case, they should. I'll give you an example of one, where you have a landlord, a commercial landlord, and he files an unlawful detainer complaint against his commercial tenant, saying you haven't paid your rent, and therefore I want to evict you. And the defendant files an anti-SLAPP motion and says, 2 weeks before you filed your unlawful detainer, I filed a lawsuit against you. And your lawsuit is retaliating against me for exercising my right to petition the court for my grievances. Therefore, your complaint should be stricken. We denied that motion to strike. We said, no, No, it didn't arise from your filing of a complaint. It arose from your failure to pay rent. The fact that conduct follows protected activity does not mean it arose from protected activity. They appealed that, and the Court of Appeal published an affirmance of it, saying, no, people should not be allowed to abuse the anti-SLAPP statute this way. An unlawful detainer is supposed to be an expedited proceeding for owners of property to get possession of their property back. They shouldn't have to wait 2.5 years like this landlord did to do the anti-SLAPP proceeding and an appeal before they can finally proceed to their trial and to get possession of it. And so, yes.
So in what circumstance is it a good idea to use the anti-SLAPP? And what type
Well,
of
there are many times that it's good. The classic example is when a political candidate sues another political candidate for lying.
We're gonna hear a lot
Okay,
about
that's
that.
public participation. In fact, our most protected type of speech under federal jurisprudence is political speech. And so it is arising from the person's First Amendment rights. And we give a lot of protection to stretching the truth in politics. I don't think I have to reference current political situations to get onto that. We give a great deal of latitude to what people say without there being any serious repercussions other than perhaps people deciding not to vote for one party or the other. There are any number of ways. For instance, have you heard of a cause of action called malicious prosecution? That's where somebody sues you and you win as a defendant. And then you bring a cause of action saying, you did not have probable cause to sue me. You brought that lawsuit in bad faith. Well, anytime somebody files malicious prosecution, it's arisen from a person's right to petition the government, filing of a lawsuit. So, in almost any malicious prosecution lawsuit nowadays, the plaintiff's attorney has to be prepared from the outset to oppose an anti-SLAPP motion. They have to be able to show that the proceeding was instituted with malice, without probable cause. So that's the anti-SLAPP. I could actually spend an entire day talking to attorneys on anti-SLAPP and all of the things in it, but I'm just trying to give you an overview of terminology today. So moving right along. Discovery. I've used that term before. In our ordinary term, aha, eureka, I have found it, says Archimedes. I've made the discovery that the volume, the mass of my body displaces an equal amount of water. That is discovery. That is not what we mean in law. Discovery is a series of devices whereby you can get people to respond to questions under oath. The utility of this is obvious. If a person gives you a response under oath, they cannot deny it later on. Not effectively. They've already sworn under oath.
You blame it on the interpreter.
They could try to blame it on the interpreter.
They could, but I'm afraid that wouldn't work. As I say, we have great deal. I'll take a digression for a moment to let you know why I have such respect for what you do. You're not there as a matter of course in civil proceedings. So when we have a non-native English speaker who comes into civil court and the judge is trying to describe why they're losing this motion, and he tries smiling and speaking distinctly and trying to use a number of ways, but the person clearly doesn't get it. He says, I'm going to send you out to talk with my research attorney for a few minutes. I had a lovely gentleman 2 weeks ago. His language is Tagalog. I can speak Tagalog. And his English. The question here, we were talking about jurisdiction earlier. He was suing a corporation somewhere in Michigan. And he just mailed a copy to the corporate's address. That's not how you serve a corporation. How can I describe fundamental jurisdiction to a person whose native language is Tagalog? Eventually, I'm reduced to pulling out the Code of Civil Procedure and saying, here is the statute about how you serve a corporation. He says, well, how do I get them to answer these questions? You have to serve them first, sir. You must serve them first before we can make them answer any questions. But I did. I mailed it to him. That's not the right way. If you read the statute, it will tell you how to file a corporate. I feel bad for telling them that, because handing them that statute is sort of the same as if I, gave you a handout in linear A, ancient minimum or something. At the legislature, people talk about legislative intent. There really is no such thing. All legislation is a compromise. And so there is no uniform intent. There is what gets through and what doesn't get through. So I understand the difficulty presented in interpreting for people. I, like you, can't give legal advice to people. I can only say, well, there are statutes that you can look at, but that's not very helpful. He says, can you get me a Tagalog interpreter next time I come in? I'm sorry, I can't do that. You'll have to bring your own. And the problem when people bring their own, normally an 18-year-old nephew or somebody, they can speak English, but they don't have the facility to handle the legal vocabulary, to explain the concepts. They can't even do simultaneous interpretation. So this is part of the challenge I see coming. We're talking about discovery now. We're talking about, and let's talk about the type of discovery there is. There are interrogatories, written questions. There are form interrogatories, which are pre-prepared by the Judicial Council, and special interrogatories that you make up yourself. The problem in law is lawyers want to be broad, so somebody can say, aha, you didn't ask that, you only asked this. So they make these really overbroad questions that are impossible to understand. And the other side just interposes a bunch of objections. Then everybody comes in marching to court. Make them answer my question. No, their question is no good. It's a real problem with language. How do you get them to answer the question that you want? How specific should you be? How broad should you be? Along with interrogatories, you can serve demands for productions of documents. Once again, this is very useful because part of your problem at trial is proving that something is what you say it is. If you can get the other side to admit it under oath, then your proof is clear. If you say, somebody's suing you for breach of contract, you can say, give me every document which you contend constitutes the contract. They now cannot dispute that whatever they send you is the contract. And they can't come back later and say, oh, no, there's also this page here that I just made up last night. No, can't do that because you are bound by your discovery responses. The most powerful of those discovery tools is called requests for admission. You can ask the party to admit to certain facts. They must either admit or deny. If they deny the fact, and you later prove that fact to be true, you can ask for your attorney's fees in having proven that fact. Requests for admissions are incredibly powerful because if somebody doesn't respond at all, that fact is deemed true. So when a plaintiff is suing somebody who has no legal training, the first thing you do is say, admit that you were responsible for the accident. If they don't answer, and if they have no training in law, they might not, they've admitted they're responsible for the accident. Later on, you can get out of your admission if you could show your failure to admit was due to mistake, surprise, and inadvertence, but you have to be able to know how to employ that procedure. It's difficult. Discovery also concerns depositions, where you can physically ask people questions in their presence. You have to bring an interpreter. It's the one time in civil that the party has to hire an interpreter. If you wish to depose somebody who's Spanish-speaking or Tagalog-speaking or whatever, at your own cost, you have to provide a certified interpreter to interpret for that person. And so that's the only place I know of that certified interpreters do get work. They have to get work in civil in that way. You can't force a defendant to provide their own interpreter. You want their testimony, you provide them an interpreter. We were talking about summary judgment. Since I talked about it, I'm going to move on. Now to the terminology. You will hear the term best evidence and best evidence rule. Anybody ever hear that in a courtroom? Anybody know what it means? It means that if you're talking about a document, you can't testify as to what's in that document. You must present the best evidence, which is the document itself. So this is a case, once again, where the ordinary English meaning can lead you astray. It does not mean the best evidence in terms of proving your case. You know, it's a smoking gun. It means that you cannot testify as to the contents of the document. You must present the document itself. That's the best evidence rule. The word beneficiary. We all know the word beneficiary. And we think about that normally as somebody who recovers a benefit, or perhaps more commonly in law, we think of that as somebody who has left something in a will or a trust. But in contract law, we have a completely different meaning for it, and it is called a third-party beneficiary. Normally, the only person who can sue on a contract are the parties to the contract. In other words, we contracted to do something, either of us can sue the other of it. Nobody else can, with the exception of a third-party beneficiary. If you enter into a contract and the parties expressly intend to benefit a third party, that person is nominated a third-party beneficiary and they have standing to sue. I go to a contractor and I say, I'm going to pay you to put a new roof on my sister's house. You're going to go over to my sister's house at the following address and you're going to replace the roof. And they do so, and they do a lousy job. And the next rain starts to flood everything in there. The sister has the right to sue because they're a third-party beneficiary. The contractor and myself, I may be paying the money, but my intent in entering the contract was to benefit my sister. That makes her a third-party beneficiary. It's not enough that it be simply an incidental beneficiary. It must be expressly with the intent that that party be benefited. Burden of proof. I like the Spanish translation in the handout I gave you says, carga de la prueba. I understand prueba to be truth. So it's using the word. Is prueba proof? It is. It is true.
Well, it's responsabilidad de comprobar.
Okay.
Proof, like the DA has the burden of proving.
The DA does have the burden. In civil, though, as I've mentioned, the burden of proof can go to both sides.
Yeah.
Now, I want to add in a new term here as well. There is not only in civil the burden of proof, there is the burden of persuasion. By being in a criminal court, you understand what the burden of proof is. Who has the initial burden of proving their case? As I mentioned in civil, the defendant can have the burden of proof of an affirmative defense. But what is burden of persuasion? Sometimes a case does not concern proof of any fact at all. Sometimes, for instance, a party comes in to challenge a statute, and they say that the statute is unconstitutional. There's no facts to prove. Everybody is going to have to admit to it. The legislature passed the following statute, and it was enacted on this date and came into effect on this day. The party challenging the statute has the burden of persuading the tribunal that it's unconstitutional. Laws are presumed to be constitutional. Therefore, when you're talking about law and the viability of law, there is a burden of persuasion. Likewise, even if you're not challenging the law, certain statutes can run 2 pages, have sentences with embedded clauses that run for 15 lines. What does that statute mean? It has so many conjunctions and disjunctions. You have to be a professional grammarian to try and make it out. You, in terms of putting forward what you think that statute means, you have the burden of persuasion.
So is that what is, cruel and unusual punishment, is that an infraction, is that?
No, that isn't that is the 8th Amendment to the Constitution.
Oh.
We cannot impose cruel and unusual punishment.
Oh, okay.
Okay, which is why we can still legally have the death penalty, although here in California that's coming up on the ballot next month. You could certainly say that killing a person is cruel, but in American and indeed in world history, it's not unusual. It's certainly not unusual. So, but killing people by a cruel method, drawing and quartering somebody, the Catherine wheel, if you know what those were. Catherine wheel was the lightest form of punishment under the Tsarist regimes in Russia. You tied somebody to a wagon wheel, and 2 guys with sledgehammers would pound on them while the wheel was circulated. Drawing and quartering was tying a person's limb to a horse and whipping them, going to opposite directions, the 4 corners of the globe, until the person is torn apart. These are cruel, and we can't do that. And now they're unusual, so we can't do it. Damages. I'm now moving to the word damages. There's lots of complications with the word damages because we can use the word in sort of a cavalier fashion. The most trivial of things can be damage. Okay? You're having a tea party, somebody drops your teacup, it gets a little chip on it, you've been damaged. Okay? There's no doubt about it that almost anything can constitute a damage. And even with my teacup example, it's not necessarily trivial. If you happen to be serving a 19th century Meissen tea service, the value of which is $25,000, then that little chip on the teacup is quite significant. But I want to bring in a Latin phrase, one of my favorites in law, damnum obsque injuria, harm without legal injury. When we talk about damages in law, we're talking about recoverable damages. It's only in modern times that we've allowed recovery for pure emotional distress. Okay? I've been so upset. And in some cases, I can understand why that's happening. But it has to be severe emotional distress. Well, now we're back to our war of the words. What does severe mean? How severe? What if the person's particularly sensitive? They have a phobia. You know, you gave them a peanut brittle jar, the type that you open up and a snake on a spring jumps out. You know, some people will be upset by having that prank. But what if the person has a fear of snakes? I think that's ophidiophobia. Is that severe emotional distress? What type of damages are recoverable? And this is a huge issue in law. We'll give you another example. You're driving your classic car and somebody T-bones you in an intersection. What are your damages? Is it the cost of buying another car like that? Or is it the cost of repairing the car that you have? There are various measures of damages. The same is true of your house. If a plane falls out of the sky and hits it, is the cost of replacement less than the cost of repair? Then the law will settle on the cost of replacement. If the cost of repair is less, then normally we'll settle on the cost of repair, unless that which has been damaged is unique, like the Meissen cup, in which case you can go with the cost of repair if you can find an expert in porcelain to do it. I only have 20 minutes now, and I want to leave some time for questions, so I'm going to speed up, or at least I think I'm going to, but I'm not, because the very next word is defraud. Defraud. Ooh. That's a very serious charge in civil law. Normally, like I said earlier, you're allowed to plead generally. You don't have to plead evidentiary facts. The exception is pleading fraud, because you're making such an onerous claim, you have to plead fraud with specificity. Most people, what is fraud?
Cheating.
No, you can cheat without defrauding anybody.
Deceit.
Well, deceit is another word for fraud.
Defraud?
Okay, he has the elements. Normally, fraud is a false statement of present material fact. Knowledge of falsity, scienter, which is intent to deceive, reasonable reliance by the plaintiff, and actual damage as a result of that reliance. That is called affirmative fraud. If I say I have some great swampland in Florida that I want you to invest in, and of course I don't have any, I'm just taking your money, that's fraud. But we have over 5 different types of fraud in California law. We've just talked about one that is more specifically called affirmative misrepresentation. But there is also fraudulent concealment, which is concealing something that you had a duty to disclose. So you're not making a misrepresentation. It can also be a fraud if you fail to say something you must say. There is a promissory fraud, a promise made without intent to perform it. It's very difficult to prove that. How do you prove somebody had no intent? Normally by showing that they had no capability of performing their promise. If a person had no capability, they probably had no intent. And because we're not dealing with proof beyond a reasonable doubt, that's enough for most juries. Fraud is an incredibly complicated area of law. And as I say, it's high monetary damages. If a jury believes you've defrauded somebody, they're generally quite generous. Most people don't like fraudsters. Process. Moving on. Exemption, the word exemption. And I notice here that the Spanish they gave is inmunidad. But in law here, our exemption has a broader meaning. And it most commonly comes in play in civil law after judgment, where somebody is running around trying to collect your assets. They can garnish your wages. You come to work one day and your boss says, sorry, I got served with this writ, and I have to pay 33% of your salary to the marshal until the judgment is satisfied. You can make a claim of exemption that a particular asset is exempt from levy. The point of this, to do it very briefly, is most of us, if somebody said we're taking $50 a month out of your paycheck every month, that wouldn't bother us tremendously. But if your total monthly salary is $500 a month, that's 10%. And people who make that little often have many children or family members for whom they're responsible. So we do not allow, as much as we want to enforce our judgments, we do not allow enforcement of the judgments to economically ruin anyone. So you can claim exemption from levy to the extent that it's necessary to support your household. Likewise, exempt if you are a carpenter and you have $10,000 worth of very expensive Snap-on tools, they are exempt from levy. The tools which you use to earn your livelihood are exempt from levy. We don't want to stop somebody from earning their livelihood. So they can claim their car is exempt. I need my car to get to work. If you own a home, your home is not exempt, but there is a homestead exemption, which means if somebody sells your house, so much of the equity is preserved for you in the form of cash. So the term exemption, when we use it in civil law, is largely referring to whether a particular asset may be levied on by the marshal. The word expunge, I like the translation there, cancelar. We use that term in terms of getting rid of various types of legal notice or restraint. If there is an action on real property concerning the title to real property, the plaintiff can file a document known as a lease pendens, meaning litigation is pending. That's Norman French. Lease pendens means notice to the whole wide world. If you buy this house, you're buying a lawsuit. Because currently, this piece of property is in litigation. No lending company will refinance it. No one will give anybody any money to buy it. It is a cloud on the title. And so there's a procedure to expunge that, to expunge the lease pendants. Likewise, if you hire a workman to work on your house and you don't pay him, he can record what's known as a mechanic's lien, which immediately becomes a lien against the real property. They can foreclose on it, get their money, and give you back the rest of the equity. It's a pretty draconian remedy because the legislature decided that workmen should be paid and should be paid promptly. But they have to seek their remedy promptly because after recording that notice of lease pendants, you have to file an action to foreclose within 90 days. If you don't do it, the notice is void. But it doesn't go away. You still have to bring a motion to expunge it. When we talk about expungement in civil law, we're normally talking about recorded notices in the public record and being able to cancel that notice by a subsequent notice saying that cloud has been removed. Hearsay evidence. Hearsay. Everybody hears that even if they just watch Criminal Minds on television. But hardly anyone really understands what it means. Hearsay, formally speaking, is testimony of an out-of-court statement that's offered to prove the truth of that statement. That is normally not admissible. There are many exceptions to the hearsay rule, far too many to give in a few minutes. I will say that it is perhaps the most common objection raised against testimony in both civil and criminal courts. In a criminal court, you have the guy who's dropping the dime. So-and-so told me that Joe did it. That's not admissible, okay? You're offering that statement to prove that Joe did it. But not all hearsay is inadmissible. It's only inadmissible if you're offering to prove the truth. I will give you an absurd example that I used to give to law students. You have a man on the witness stand, and his testimony is, "My father told me he is Batman." Well, if the nature of his action was that the Batmobile ran over him in an intersection, then that would be inadmissible because he would be offering it to prove that his father is Batman and therefore the responsible party. But if he was in a probate proceeding to prove that his father was incompetent, that same statement is admissible because he's not offering it to prove his father is Batman. He's offering it to prove that his father is delusional. So, when we use the word hearsay, always make in your mind that distinction between inadmissible hearsay and admissible hearsay. Certain types of out-of-court statements are admissible even if they fall, for instance, everybody's favorite, the dying declaration. If, like in the movies, the person has a knife in their chest, and they go, choke it, and then they die. That is admissible, even though it's being offered for the truth, because the law says nobody would lie when they're dying with a knife stuck in their chest. Likewise, birth dates that are inscribed in the family Bible are admissible to prove birth dates. Why? Because in our Judeo-Christian culture, nobody would write a lie into their family Bible. So it all comes down to making these determinations of whether testimony is sufficiently reliable to introduce it to the jury. I briefly want to hit the term, I just want to say, I put in words that they put in this thing, they put in the words here and after, heretofore, hereunder. I taught legal writing, and whenever I said to my first year law students, I said, anybody who uses any of these words will do no better than a C in this class. It is entirely unnecessary to use this kind of archaic language. I'm an advocate of the plain language school, that lay people should be able to understand their contracts, that they should be able to understand legal proceedings. It is not necessary, I think, to do that, but you might be called upon to interpret some insurance document in which it's there, so I won't say it's irrelevant. I will say that any decent lawyer shouldn't be using those words anymore. Indigence. We know what the word indigence means, but it has specific legal meaning in court. You don't really have to be out on the street with a can and a sign to be indigent. It's just like the same principle that we were talking about with levying against people they need to support themselves. To be legally indigent just simply means that you are below a certain income level, in which case we waive the court costs. But if you win, we get it back from you from your recovery. Misrepresentation covered that, motion covered that. In Connecticut, they must have something called motion for judgment. There's no such thing in California. We have motions for summary judgment, we have motions for judgment on the pleading, we have motions for judgment notwithstanding the verdict. We do not have any other motion for judgment. They could be referring to what we call a directed verdict. I don't know. Motion to withdraw. That only has one context. That is when an attorney wishes to stop their representation of a client. They cannot just abandon their client and say, I quit. They must bring, if their client does not consent and file a substitution, they must bring a motion. Easy motion to do, and most people blow it. It's on a judicial counsel form. If your client is not paying you, of course, we let them withdraw. If you say there's a conflict, an irremediable conflict, normally that means that the client wants the attorney to do something that they ethically cannot do, like let them lie on the stand, in which case they're required to withdraw. Negligence, we talked about briefly. It is the most common tort theory that there is. It's simply want of due care, lack of due care. Most tort liability is based on accidents and not on intentional conduct. Opening statement. An opening statement in law has been totally confused by movies and television. It is not supposed to be advocacy. You are not supposed to argue the case itself. An opening statement in civil law is supposed to be limited to an overview of what the case is about and what evidence you're going to present. Ladies and gentlemen, this case is about a terrible automobile accident that the evidence will show took place on October 1st, 1913, and that the plaintiff, who was stopped at the red light, was, you will hear her say that she was stopped at a red light when the defendant, driving 60 miles per hour, rear-ended her, forced her car into the intersection where she was hit by the co-defendant, and we will bring in doctors to tell you that she will never lead a normal life again and will need 10 spinal surgeries in the future. That's what an opening statement is supposed to be. Not talking about how evil the defendant is. Pain and suffering. Damages, we used the word damages before. Law divides these into two parts, special damages and general damages. Pain and suffering are general damages. If you have been physically injured, it is presumed that you had pain and suffering. You do not have to prove that you had pain and suffering, but you better have some evidence, normally your own testimony, of the extent of your pain and suffering. Despite what most attorneys believe, there is no ratio of general damages to medical costs. It is possible to have a very expensive medical procedure which causes virtually no pain and suffering. It's also possible to have a very simple procedure that causes tremendous pain and suffering. By this, without going into it further, I simply refer to a case I once had for wrongful circumcision. Not a lot of medical specialists there, but a great deal of general damages, a great deal of pain and suffering. So, special damages must be specifically pleaded and proven. Those are things like your medical damages. You have to plead that you went to the hospital and that you paid doctors and that you had to hire a nurse to come into your house. You have to plead and prove those special damages. If you're charging somebody with unfair competition, you have to specially plead and prove how that competition damaged your business. Those are special damages. Nothing is presumed. You must plead the fact of that damage and you must prove it at trial. General damages, they are presumed. If somebody punches you in the face, you do not have to testify. That was painful, and I suffered. You don't have to get up there and say that. You do want to get up and say they knocked out a tooth. You do want to get out and say they did that in front of my entire family and I was extremely embarrassed, but you do not have to specifically plead or prove it. Probative value. It's important to understand the word probative value. I have 2 minutes left, so I'm going to stop right now and not even get into probative and ask if anybody has any questions about anything dealing with civil law. Yes?
Tort.
A tort is a civil wrong independent of contract.
A civil wrong independent of contract. There's no contract.
There's no contract. It means it's a civil wrong, like negligence or intentional infliction of emotional distress or battery. Okay? It is a civil wrong, but it has no contract underneath it.
Okay.
Okay? Any other questions? Yes.
Just repeat for the discovery once more.
I'm sorry?
Discovery once more. Repeat discovery.
Oh, discovery is a series of procedures whereby you get a party to answer questions under oath.
And under discovery.
I have a person waving around in that.
Why do you call it mechanic's lien, and maybe the guy is not a mechanic?
Right, exactly. You'll have to go back. I will point out to you that if you read the plays of Shakespeare, like Midsummer Night's Dream, they refer to all of the craftsmen in the village as mechanicals. In Elizabethan English, a mechanic was anybody who did skilled physical labor. Yes?
Under discovery, you mentioned there's different types of discovery.
There are,
One
like
of
I
them
said,
is
there are
interrogation
interrogatories, requests for production, requests for admissions.
and special interrogatories.
Yes, special interrogatories are, you just write the question you want them to answer.
Oh, okay.
Okay, for instance, normally these are contention interrogatories. Please state every fact on which you contend I'm liable.
Oh.
Any other questions?
Yeah, okay,